Good morning. This is lecture number one for the Interpreting in Superior Court Felony class. So we are now in the second course of what I consider the key course for to make you really an interpreter. And by that I mean we already look at the first one, which is the Superior Court class, and that was last quarter. And many of you did very well in your final examination, but there's still some of you still need some work, and that amount of work needs to be, kind of work. We need to do some additional work during this class. Let me talk a little bit about this particular class. This class is very much easier than the previous one. You're going to find that if you compare the two, there's really no comparison. The other one was pretty intense. This one is definitely much easier. However, there are new things that you need to study. If you were to look at the class manual, there are plenty of pages there. Most of those pages are really mainly for reference material. There is, I think, in page 50 something. I'm going to show them to you here on the screen later on. But there is a substantial number of pages in the manual. And doesn't mean you're going to study all of those. But remember, this is the last course before you're really ready to interpret in the court system. So I included a lot of, reference material, such as material that deals with juvenile court, material that deals with civil court, expert witness testimony, and so on and so forth. So this is one of those classes where you will learn a lot of new things, but not too many, honestly. However, you will need the free time that this class will give you to go back and review things from the previous class. This is sort of a continuation of the previous one, if you think about it. And the purpose of this continuation of this class will be basically to go back to the previous one, review the material. The question is, why would I say that? Why is it such an easy class compared to the previous one? Well, we have learned our advisement of rights. We have learned our rights. The rights are the same regardless, right? So we have learned the rights. And those rights are applied from the Superior Court misdemeanor to the Superior Court felony. The rights are the same. They're not dependent on what type of crime you committed. So that material is already pretty much under your belt. And the only major differences between felony and misdemeanor court is that in felony court, there might be certain variations of the California Judges Bench Guide. And those variations are usually minor. But again, as I told you, if you memorize the whole thing, it will be more difficult for you to kind of transfer the knowledge that you acquire in the previous course to this course. So you got to memorize the rights, obviously. You got to memorize different structures, different portions of it. But you have to be open to any variation in terms of the plea, when they change the plea, any variations in terms of the way the rights are read to the defendant. And this is because each judge has its own approach, and felony courts sometimes have a different type of forms that the interpreter has to read to the defendant, such as, for example, in felony court, you don't have DUI forms, like what you study under Lecture 2 in the previous course, because DUI is a misdemeanor. They don't have anything that has to do with misdemeanor advisement of rights, because this is felonies, right, in this class. They don't have, in felony court, they do not have anything that has to do with crimes that are basically minor crimes, where there is probation involved, because in felony court, although there is a little bit of, there is a possibility of getting probation, but it is not, it's minimum, very minimum. So as you will see here is that felony, which people think felony will probably be more complex because the crimes are more serious. In fact, it's just the opposite. Felony court is much easier to work in. Felony court it's a court where the defendants they take their time. So that means that a defendant can be appearing for 8-9 months, whereas in a misdemeanor case, sometimes like a driving under the influence of alcohol is just one appearance and that's it. So the main purpose of the interpreter really there is just to interpret everything, of course, but the difference between misdemeanor and felony court, in misdemeanor is very quick. You got to really move, whereas in felony court it's way slower. And it is slower for various reasons. In a felony case, people are going to be sentenced to state prison for prolonged periods of time. It could be 20 years or it could be life in prison. It could be 5 years, 2 years. So that's not the case in a misdemeanor case. Misdemeanor case, it's going to be up to 1 year maximum, and it goes to county jail. And it's important that we know the difference between county jail and state prison. Of course, state prison in Spanish is penal estatal, as you probably already know. And the main difference between these two, state prison and county jail, is that when you go to county jail, number one, you will get some probation that reduces the number of months that you will spend in county jail, as we have seen in the previous course. The time that you served in county jail, it's not necessarily the time that you are sentenced to. So if you're sentenced to a year, you may serve 5 months, 4 months, because there's plenty of credit applied to county jail. In felony court, there is no such credit. So if they give you 2 years, it's actually 2 years, no credit for anything. Furthermore, in felony court, there is no possibility of getting probation to reduce the punishment. So what happens in felony court in most cases is that if you are given an offer, okay, because the process is exactly the same. You have pretrial hearings, you have preliminary hearings, you have all that. But if you are given an offer in a felony case, you meaning the attorney for the defendant, let's say, you consult with your client, and the client is going to say, well, do I go to trial or do I get this offer? And the offer, let's say that the maximum time that you should spend in state prison for this crime is 9 years. And the minimum is 3. So the offer is 3 years. If you risk it and go to trial and you lose, you're going to get more than 3 years. You may get 4, 5, 6, 7, or 8, or even 9. In which case, going to trial is a risky proposition. If you consider it in a misdemeanor case, where the maximum time is 1 year, let's say that for a misdemeanor case, the maximum term in jail for your crime is 9 months, and they give you an offer of 3 months. You may want to fight it because the difference might be 2-3 months. Maybe they give you 6 months. But when you add the credit and all that stuff, it might be 3-4 more weeks. So there's more incentive to try to go to a trial and see whether you win that. But in a felony case, going to trial, carries an incredible amount of risk. 3 years now versus the potential of up to nine years if you lose your case, your trial. People think about it. So what I'm trying to tell you is that most felony cases end up in pleas. They do take the offer, they meaning the defendants, and they do actually. There are very few trials. So that's good from the point of view of the interpreter, because it's much easier to do a change of plea or enter in a plea of guilty. In felony court, the pleas are guilty or no guilty. It's no contest is usually not used in felony court. So in those cases, what makes this very slow is the following. Look at it from this point of view. So let's say the offer as an attorney, is going to be around 3 years. You remember there were 2 pre-trials, right? One right after the arraignment, one right before the trial. So in the one right after the arraignment, they give you 3 years. So they tell you, okay, it's only for today. But you already know that the district attorney intends to give you the low term. So what you as an attorney for the defendant will suggest me, let's say I'm the defendant in this case, is to delay this whole thing so that I spend as much time as possible in county jail. Why? Well, if I spend, let's say, 9 months in county jail, actual 9 months, I'm going to be giving credit because I was in county jail. So the 9 months become almost 2 years. So by the time I'm taken to state prison, I will get that credit of 2 years. I actually didn't serve 2 years. I served 9 months only. But because I serve it in county jail and I'm entitled to that credit, when I go to state prison, I'm going to serve only the remaining amount of time. So what that means is that if you as an attorney can keep the client, that's me, in county jail for 9 months, in this particular case, then that person is going to end up in state prison only for 1 year. And if you can extend it to 10, 11 months, maybe he goes to state prison for only 5, 6 months versus the 3 years that he was sentenced to. So there are these delaying tactics from the part of the attorneys to make sure that the defendant spends as much time as possible in county jail because of the fact that the defendant gets credit, because of the fact that it is a better environment to be in county jail versus state prison, clearly. Because state county jail is in the city, where state prison is usually the outskirts or outside the city, so people can come and visit the inmate easier. So all that type of combination, okay, all those circumstances make the attorney for the defendant push for a delay as much as possible. And that's something that we see quite often, as a matter of fact. And therefore, when you work as an interpreter in felony court, everything is at a slower pace, really slow pace. You will see that quite often court interpreters who are assigned to felony court in the afternoon, they have only maybe 1 or 2 cases. Now, in the morning is a little bit more busy, but most of the interaction that the interpreter has to deal with in felony court is basically when the attorney asks the interpreter to come to the cell to talk to the client. Occasionally they have to appear, they meaning the defendant as well as defense counsel, of course. They both have to appear in court to kind of gain more time, try to get more time. There might be a motion filed, or maybe this, maybe that. It's quite interesting because there are some defendants who have experience already in these issues. Obviously, they have been in county jail before. And what they do is they require to represent themselves. And at the very end, they end up getting a public defender. But by allowing the defendant to represent himself in felony court, that gives the defendant, first of all, the ability to delay things, right? Because, I didn't know, whatever the case is. And number two, and that's very important, is that they are given, I think, 7 or 8 hours a day where they can go to the county jail library or library that is within the county jail, obviously, and spend the time that they need to prepare for the case, which is much better than being in the cell. So there are all these things that you will see defendants do, all these kind of tricks, right, that they do. And the whole purpose of those tricks is to stay in county jail as long as possible. So as a result, for us interpreters, we make it, it's a much more relaxed job. Now, I have to say, however, that when the case ends up in a trial, the stress level increases dramatically, because a trial in a felony case where the defendant, if he loses the case, will go to jail maybe 2-3 months extra, versus a trial in a misdemeanor case, versus a trial in a felony case where if the defendant loses the case, will go to jail 3, 4, 5 years more. There is more interest on the part of the attorney, both attorneys, to make sure that the interpretation is accurate. And that puts a lot of stress. That puts a lot of stress on the interpreter, but not a lot if you know what you're doing. The other thing that you will see in felony court that it is kind of unique to felony court is that the forms that when the defendant takes the offer, which is 95% of the cases, maybe even more. When the defendant takes the offer, the only form that you have to read to the defendant is just one form. It's called guilty plea in superior court. And we're going to see it is in your manual. And the guilty plea in superior court is basically a much easier form and shorter form than the ones you have to study for misdemeanor cases. See, for misdemeanor, we have forms specifically to DUI, to domestic violence, to sex-related crimes, so on and so forth. Whereas for felony, it doesn't matter because all the crimes are classified as felonies, and there is no condition of probation, really. These forms are really long, the misdemeanor ones are, because there's probation involved. But in the case of felony, there is no probation. There is only one option for you to get probation, which we will discuss shortly today. So as an interpreter, you can think of it, felony court being a better assignment, but they usually don't send you to felony court as a regular assignment until you have some experience doing misdemeanor courts. They know that in misdemeanor court, you really earn your money, you really work hard, whereas in felony courts, it's much more relaxed. And most interpreters request felony courts. And because you don't have the seniority, when there is an opening in felony court, it's going to go to the one who has been working more years for the county. You will, however, at the beginning, it's possible you're sent to felony court in the morning and maybe misdemeanor court in the afternoon. When we talk about felony court, we are really talking about not only criminal court, though. See, a felony court involves, of course, criminal court. But there is also juvenile here. And there is civil court. And within civil, the main cases that you will see is family law, conservatorship. This comes from the probate department. And unlawful detainers. These are the typical one that you will do in felony court. So what that means is that if you're assigned as an interpreter in felony court, you will be doing criminal court, of course, which is the material that you have already studied and we continue studying here. But then there is also some possibility that you are sent to juvenile court and to civil court. In fact, that courthouse, which deals with felonies, there will be one or two or three departments on maybe second floor or eighth floor, whatever, dealing with juvenile and civil court. The most of the cases are in criminal court, but you do get to interpret in juvenile court and in civil court. So if you're assigned to felony court, don't expect only criminal matters. There will be criminal matters as well as juvenile matters as well as civil matters. The percentage is going to be more like 90% here and 10% here. So when you look at the class manual for this course, there is an area there that talks about reference. We're going to look at it later on. And within the reference material, there is vocabulary that is applicable to juvenile court. Because remember, the terminology changes in terms of the jurisdictions, right? And when it comes to civil court, this family law, conservatorship, and lawful detainer, we're going to see that all of that in the last course in this program. But there is some material also, I believe, in the reference material there. And this is just unique civil court material. So an interpreter in felony court tends to be going to more variation of cases, which really means that there are different jurisdictions. So you have three different jurisdictions: criminal for adult, criminal for juveniles, and civil court. And those three jurisdictions may have different terminology. For example, you wouldn't use for the word district attorney is not used as such in juvenile. The juvenile court is known as petitioner. And unfortunately, the word petitioner is also used in family law, which means something else. So you can see that the words now are very much a function of jurisdiction. And that's important. So we need to discuss that, and we'll discuss that in this class as well. But this is kind of the logistics of what you will be doing when you are interpreting in felony court. The most important or the most common cases that you will be doing in felony court are criminal court in felony court, of course. This area, the criminal material that you will be dealing with. They're mainly they're mainly crimes that are related to drugs. Occasionally you have some type of robbery cases. I'm talking about a typical case where you need an interpreter, right? So felony cases where you need an interpreter usually overwhelmingly is drug related. There might be some robbery cases, very occasionally a attempted murder case, very occasionally a rape case or attempted rape. And you may have other crimes that you may not even think about, such as, for example, cheating the welfare system, or creating fake companies to take benefits of, payments from the government. Because remember, if anything where the government is a victim, it's going to be a felony. And the government, deals mainly with when you cheat Social Security or any of that stuff. The government is the party that is the victim of the crime. So that's going to be a felony. So you occasionally get those. But overwhelmingly, it's all about drugs. It's all about possession, trafficking. Oh, you also get occasionally issues that have to do with trafficking of weapons. So you can see that there is going to be specific vocabulary that deals with weapons, specific vocabulary that deals with drugs. and there will be expert witness testifying, and those expert witnesses are going to talk about fingerprints. All that information is provided to you in the manual for this class. There's one section that says reference material, and anything that you see after that, you will. It's all really good stuff to have handy. In fact, those sections after the reference material page are sections where I put all the words together, like in sentences. So I divided all that legal vocabulary and stuff into different proceedings. So we're going to see that shortly as to how to access. In fact, let me just how to use that, because that's very, very important from the point of view of having that as a reference material in your for your future career. In fact, you will see a lot of people carrying that stuff with them. Some of them makes it somehow shrinks that, and what they take that in court. They do that a lot. They will take it to court, and when they do that, they use it in court, but not while they are interpreting, right? They review it in court, particularly at the very beginning. So let me show you what I am talking about. Let me just access this site so I can show you what we are talking about in regards to the reference material.